this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government.
But he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases.
Yes.
Because of his subjective assessment that the majority was cobbled by illegal and unethical means. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What
expression I have borrowed from Bomai, from wherever derived, because this was an expression used by the committee of governors appointed in 70s, and Bomai has approved that report, my lord, can only arrive at a conclusion that prima facie the cabinet or the chief minister has lost confidence, support of the house, which requires to be tested on the floor of the house. His satisfaction is limited only to the requirement of floor test and not whether A enjoys majority or B enjoys majority. Now, my lord, your lordship's very pertinent question was that if, I'm sorry, my lord, your lordship, sorry, that merely because there is some internal dissatisfaction amongst the party, can the governor take this call or not? Lord, a similar question arose, my lord, in case of Rameshwar Prasad, where the question was that you're permitting somebody to request you to hold a floor test would violate 10th schedule. Because what these people, this group who is expressing no confidence against the chief minister, stand disqualified or will stand disqualified under the 10th schedule. And the question before the court was whether the governor, while taking a decision under Article 174 and 175, is concerned what will be the effect of their act ultimately in the 10th schedule. I hope I'm able to make myself clear. While taking the decision, I am supposed to be cognizant that what they are doing might be a reason for 10th schedule punishment, a consequence subsequently. Your lordships, my lord, through a constitution bench says no. My lord, please take, my lord, Lord, 2006, volume 2, SCC, page 1. I'll read only 4 paragraphs on this point. That governor is agnostic to 10th schedule. He has to be satisfied that the confidence is lost prima facie. It needs to be tested on the floor. They may suffer consequence, they may not suffer consequence. That's not the governor for the governor to see. That's what your lordships have said. Lord, kindly see PDF page 393 in JC volume 1.
There are 2 important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed
which brings it down to your lordships are.
So out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a 3-party coalition, the dissension has taken in 1 party out of the 3. The other 2 are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the 3 are virtually at par, except the Congress, which was a little lower.
May I only make one request? To examine the facts of the case, after, my lord, I show the law, your lordships are shown, but some of the paragraphs, some of the law is unfortunately, my lord, not assisted.
2006?
Thereafter also, my lord, why the governor can take that step, even if NCP Congress block is not disturbed? I'll, my lord, answer that. Lord, it is para.
What is the citation, Mr.
Lord, 2006, volume 2, SCC, page 1, para 85.
Which compilation is it?
Well, judgment compilation 1. My lord, PDF page 482.
Starts from page 393.
Yes, yes.
Want to go to 482.
482, my lord. Para 85. I am reading 85, 161, 164 and 165, which is on this point, my lord. And my lord, kindly bear one factor in mind. My lord, whether the court would have taken the same view which the governor took may not be the test while determining, my lord, the decision taken by the governor. Court may perhaps on the facts arrive at a different conclusion. Lord, 85. Certainly there can be no quarrel with the principle laid down in Quixote case about the evil effects of defections, but the same have no relevance for determination of the point in issue. The stage of preventing members to vote against the declared policies of the political party to which they belong had not reached. If MLAs vote in a manner so as to run the risk of getting disqualified, it is for them to face the legal consequences. That stage had not reached. In fact, the reports of the governor intended to forestall any voting and staking the claim to form the government. Well, this was a case of 356. He sent a report that now dissolve the government. Yes.
The stark distinction so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections.
Correct.
Where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the governor has drawn. But as against Rameshwar Prasad's case, this is a case where the government is subsisting for more than 3.5 years. So that's the distinction between Rameshwar and ours. I'm just putting it to you.
Facts, yes, but the legal proposition which I would, my lord, place for your lordship's consideration may be the same. The consequence which would, the power of the governor or the exercise of power of the governor at the time of initial formation or subsequent shall have to be the same. That's my respectful submission. Please come to, my lord, now PDF page 520. My lord, what fell from, my lord, the Chief Justice would be, my lord, if I put it in the context of this ratio, would be that the governor will have to first form an opinion that these people are working since 3 years. They have a reason to, they have shown the reason to the governor why they are parting ways after 3 years. But can they do it after 3 years? Would it not amount to a split? Would it not amount to disqualification under Chapter 10, Schedule 10? Now, kindly come to, my lord, 160. That assumption come to the conclusion that there would be violation of the 10th schedule and use it as a reason for recommending dissolution. Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I
see,
earnestly request your lord.
but we are since beyond those two paras, just those two paras. No such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule.
They would.
For the governor,
They
he
would.
has to treat these as part of the Shiv Sena, irrespective of what their internal dissension is.
And say,
Therefore, he cannot now say that these 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the house? Prima facie, at least, for him.
Now, my lord, let me show the judgment of the High Court, which was dealt with by Bomai judgment. Your lordship's, my lord, very right concern, my lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your lordship in Bomai did not accept that rejection. Kindly, my lord, allow me to place, my lord, that High Court judgment, my lord. Kindly pause here for a minute. My lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, so there is a provision that the party may condone it within 15 days. So governor cannot say that I'll wait for 15 days when he is presented with the facts that this is the dissatisfaction. The government has lost majority. There are attacks taking place. There is vandalism taking place, threats being administered. Then I'll not wait for 15 days. Because party may.
Mr. Solicitor, there are two
Lordships are examining proposition.
Right, there are two distinct things. One is a dissatisfaction within a party, right? And the other is the loss of majority of the government. One is not necessarily indicative of the other.
Correct.
Now tell us, in this situation which we had over here, we now put ourselves in the shoes of the governor. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What was the factual basis for him to conclude?
Again, my lord, only, my lord, one thing. My lord, kindly bear one.
Only one 34.
Who were part of the government, who were supposed to be having confidence of the chief minister.
Right. So
Second,
therefore now let's go to the bottom of it.
Look, can I first take the lordships to the bottom?
What is the governor saying? These 34 who are part of the Shiv Sena have now expressed their dissatisfaction with the leadership of the Shiv Sena. Unless the governor says that the natural corollary is that these 34 will cease to support the Shiv Sena.
I'm sorry.
Sorry. Not even that. We will make every assumption in favor of the governor's decision. Because that's how we test the proposition. What could the governor have said, though he doesn't say that these 34 persons who are part of the alliance between the Sena, the Congress and the NCP have now expressed their dissatisfaction.